to can you tell the judge at what time was it that you went over this form or this interview began?
It was at 1:20 in the afternoon, 13:20 hours.
Okay. Your Honor, I tender State's Exhibit Number 1 into evidence.
No objection for the purpose of this hearing.
Mr. Cross, do you have any objection?
No, sir, no objection.
Submitted without objection.
And is there also a transcript of this interview that you've had an opportunity to review?
There is.
And based upon this transcript, did you Mirandize Mr. McNabb at approximately 1:20 p.m. on this date and time?
Yes.
Now, this form that we've just tendered into evidence, is this a form that you previously testified that you used as a go-by, if you will, to assist you in reminding the defendant of his rights under Miranda?
It is.
And can you tell the court specifically what rights you advised the defendant of?
Well, all five of them, we advised that he had the right to remain silent. The form says anything I say can and will be used against me in a court of law. I have the right to talk with an attorney and have that person present while being questioned. If I cannot afford to hire an attorney, one would be appointed by the courts to represent me before questioning. And the last one is I can exercise my rights at any time and not answer any questions or make any statements.
And with respect to the actual interview, when you went over each one of those rights with Mr. McNabb, did he indicate that he understood each one of those rights verbally to you?
Yes.
And did he do so by, after each one of those rights being advised to him, did he inform you, yes, sir, after you asked him if he understood what those rights were?
That's correct.
And did you actually have him initial the form as well next to each one of those rights to affirm that he understood the right that he was giving up in order to speak with you about this case?
I did.
And did Mr. McNabb then sign that form indicating that he was waiving his rights?
He did.
Can you read the statement there that he acknowledged by his signature?
Sure. It says, having these rights in mind, I wish to speak with law enforcement. I have not been promised anything, nor have I been threatened, coerced, or forced in any way to make this statement.
Okay. Now, again, with respect to this first interview on October the 7th, this is just hours after the child, Leah McNabb, had been reported missing by the parents. Is that correct?
That's correct.
So with respect to that particular interview, was Mr. McNabb at that time under arrest for any charges?
No, he was not.
And for purposes of your investigation, was he in custody at that time?
No, he was not.
Did he voluntarily agree to come to the sheriff's office and speak with you about his child that was missing?
He did.
Was he released after he spoke with you that evening?
He was.
Was he offered anything to drink or during
Yes.
the interview? At any point in time, was he deprived food or a restroom break or anything of that nature?
No.
Did you offer any slight hope of benefit or reward for him to speak with you?
Not at all.
Was he handcuffed or in custody during this first interview?
No.
So he was not restrained physically in any manner?
That's correct.
Did at any point in time during this conversation or interview interrogation that you had with Mr. Christopher McNabb on October 7th, did Mr. McNabb inform you that he wished to invoke any one of these rights, such as the right to remain silent or the right to have an attorney present?
No.
Did he ever ask you to stop the interview?
No.
Did you threaten him in any way or coerce him to give you any statements in regards to his missing daughter?
No.
Generally speaking, overall in this interview, was this a friendly, conversational tone interrogation?
Yes.
All right, now I'm going to draw your attention to the following day, October the 8th of 2017. Had circumstances changed in this investigation from October the 7th when you were looking for a missing infant child that was 15 days old to October the 8th, 2017? Did you find the child?
Yes.
Where was the child located?
She was located off the side of the road, off of Henderson Mill Road.
Was she alive?
She was not.
And was that location where she was located in close proximity to where both defendants lived?
Yes.
Was Mr. McNabb charged on October the 8th with warrants for murder?
No.
Was Mr. McNabb nonetheless being looked for by law enforcement because he had an outstanding warrant?
That's correct.
What was the nature of the warrant that was outstanding on Mr. McNabb?
It was a probation violation out of Bartow County, I think.
And were law enforcement officers, including yourself, seeking to find Mr. McNabb in connection with that arrest warrant, and also with respect to wanting to speak to him again regarding now his daughter being found on the side of the road?
Yes.
And was Mr. McNabb eventually taken into custody on October the 8th by members of the Newton County Sheriff's Office?
He was.
And was he transported back to the Sheriff's Office under arrest then for a probation violation warrant?
Yes.
So when you encountered him on October the 8th, 2017, was he in custody at that time?
He was.
Was he in custody for anything other than the probation warrant at that time?
Not at that time, no.
And did you have the opportunity on October the 8th then to sit down and speak with Mr. McNabb again in an interview room at the Newton County Sheriff's Office?
I did.
And did Mr. McNabb have handcuffs on him at this time? Was he restrained?
He did.
And was Mr. McNabb, backing up just a little bit with respect to the circumstances of his arrest, was it raining that evening, do you recall?
Yes.
Was Mr. McNabb out and about on Highway 36 in the rain?
He was.
So when Mr. McNabb encountered you on the evening of October the 8th, 2017 in the interview room, can you describe generally what his appearance was and condition was?
He was soaking wet. His clothes were soaked all the way through. He was dripping wet.
Okay. Was Mr. McNabb offered, again, something to drink during this interview?
Yes.
And who else was present besides yourself, if anyone?
In the interview?
Yes.
Corporal Freeman.
All right, and that is Wade Freeman of the Newton County Sheriff's Office?
That's correct.
All right, I'm going to show you State's Exhibit number 2. Do you recognize State's 2?
I do.
And what is that?
It is original of the Miranda rights waiver that we went over on the 8th.
And can you tell the judge, again, what rights did you advise Mr. McNabb that he had with respect to agreeing or not agreeing to speak with you?
Sure, it was identical to the previous form. It says I have the right to remain silent. Anything I say can and will be used against me in a court of law. I have the right to talk with an attorney and have that person present while I'm being questioned. If I cannot afford to hire an attorney, one would be appointed by the courts to represent me before questioning, and I can exercise my rights at any time and not answer any questions or make any statements.
And did, again, was the same acknowledgement of a waiver of those rights authorized or signed by Mr. McNabb?
Yes, it was.
And again, this was on October the 8th, 2017?
That's correct.
Your Honor, I'd offer State's Exhibit number 2 into evidence.
No objection, first reading.
Mr. Frost, do you have any objection?
No, sir, no objection.
It's moved without objection.
Did Mr. McNabb then agree to waive those rights and speak with you on October the 8th, 2017?
He did.
Now, and again, I'm just going to show you a copy of the first few pages of the transcript of that interview. Have you had an opportunity to review that transcript?
I have.
At the very beginning of the interview, was he not offered something to drink, water, or anything?
He was.
Was he offered even to have ice placed in it if he wanted ice?
That's correct.
Did he request any ice?
No, he didn't want any ice.
He said he didn't like ice, is that correct?
That's correct.
And so then at that point in time, did you begin to question him about his child and the child's death during this interview?
Yes.
And at some point in time during this interview, after he had been advised of his rights, including the right to not speak to you, did he invoke that right and tell you that he wanted the interview to be ended?
He did.
And can you describe exactly how that occurred to your recollection?
Sure. We were going over an issue that he had posted on Facebook the night previous. He got very upset, pounded his fist on the table, and for lack of a better term, he screamed, "I want a lawyer, I'm not answering any more fucking questions."
And did you then at that point in time end and cease the interview with Mr. McNabb?
Right away.
Now, was Mr. McNabb subsequently charged with murder in the following hours?
He was.
I'm going to fast forward then to December the 13th of 2017. Did you have the occasion to speak with Christopher McNabb on that date and time?
I did.
Now, he had already invoked his right to remain silent and a right to have an attorney present at the October 8th interview at the very end, and you stopped talking to him. Why is it that you went back and spoke with him on December the 13th of 2017?
He sent up a request to speak with me specifically. I went down and got him.
Where would he have sent a request from? You said send it up?
He was in the detention center in the jail.
Okay, and so when you said he sent it up, was it something that was a verbal or written request?
It was a written note that I believe one of the jailers wrote stating that he requested to speak with me.
All right, I'm going to show you what's been marked as State's Exhibit number 4. Do you recognize what States 4 is?
I do.
All right, what is States 4?
This is the note that was written by Corporal Wade, who is a detention officer supervisor. This note was written on the 11th. I didn't receive it until the 13th.
Okay, and is this the same exact note that you were forwarded as a request from Mr. McNabb via jail staff to speak with you?
It is.
I'd offer State's Exhibit number 4 into evidence.
No objection.
No objection.
Live without objection.
And can you read what the note said?
Sure. It's addressed to me, Investigator Alexander, dated December 11th, 2017 at 1500 hours. Today, during his duty in Max, Deputy Jordan came upon inmate McNabb, whom stated he has information about his child's death. This very same message was also given to me by McNabb, and me being Corporal Wade, the C-shift supervisor.
And as a result of receiving this notification that McNabb wanted to speak with you, did you attempt then to go speak with Mr. McNabb?
I did.
And is that on December the 13th of 2017?
That's correct.
So I'm going to show you State's Exhibit number 3. Do you recognize what State's Exhibit number 3 is?
I do.
What is State's Exhibit number 3?
This is the Miranda rights waiver form that I went over with Mr. McNabb on December 13th.
Is that the same exact form that you've gone over twice before in this hearing, same form used in both of the October 7th and 8th interviews?
It is.
And was the same exact acknowledgement of a waiver of right on each one of those rights initialed by Mr. McNabb?
They were.
And is his signature also placed on the form indicating that he wished to waive his rights and speak with you without an attorney present?
It is.
All right, I've offered State's Exhibit number 3 into evidence, Judge.
No objection.
Live without objection.
During this interview with Mr. McNabb, did you threaten him or coerce him to give you any statements?
I did not.
Did you offer any hope of benefit or reward if he were to speak with you?
No.
Was he deprived of food or drink during this interview?
No.
Were any of these interviews, 1, 2, or 3, lengthy interviews in terms of long amounts of time that he's sitting in an interview room being questioned?
Yes, they were.
And which one was that?
The very first one, he was in the interview room approximately 5 hours total.
Okay.
And the third interview we did in December was a little over 3 hours long. We were in the room together.
All right. Well, specifically with the first interview, he was in the interview room for 5 hours and 46 minutes, but he actually spoke with you starting at 12:15 and ending at 2:30, or excuse me, starting at basically, I think you said 1:20. And so with all the starts and stops, the interview was just a couple of hours. Is that
That's
correct?
correct.
And with the second interview, that was roughly 50 minutes and 47 seconds.
That's correct.
And the third interview was 2 hours and 28 minutes long, the one that he requested.
Sounds right, yes, ma'am.
Okay. So none of those were like 5 hours. He wasn't being interviewed for 5 hours. He may have had gaps where he sat in the interview room while you were gathering information.
That's correct.
Okay. Now, with respect to this last interview that you had with McNabb where he requested to speak with you, did you in fact begin your interview with him by establishing that he was the one who wanted you to come down and talk to him? Is that
Yes.
correct? Was this interview conducted in the interview room as well?
It was.
And was it reported both with audio and video equipment?
It was.
And have you had an opportunity to review the transcript or the recording of that interview?
I have.
All right, so I'm going to show you a copy of that transcript and ask that you just summarize your beginning statement that you made to Mr. McNabb on that date and explain that to the judge so he knows how you began that interview.
Sure. I began that. I did the date and the time in the afternoon. And I said, Chris, I received a note. And then I read the note. I'm up here with Christopher McNabb. I received a note from Corporal Wade, who was the shift supervisor down in the jail. And it says investigator, and it was dated on the 11th, which was the Monday prior to. Today, and then I just read what the note said. It said, today during his duty in Max, Deputy Jordan came upon inmate McNabb, who stated that he had information about his child's death. The very same message was also given to me, which would be Corporal Wade by Mr. McNabb. Is that right?
And did he acknowledge that in affirmative?
He did. And then I asked him, I said, so you made the outreach to me, and he wanting to speak with me, and he said, yes, sir. He said a couple of times he sent a note, but I only received the one.
So he had said that he had previously reached out to you and wanted to speak with you,
That's correct.
and you had not received that information?
That's correct.
And so, again, you advised him of his rights at that point in time.
I did.
And he went over and acknowledged each one of those rights with you.
That's correct.
And then you asked him, do you want to talk to me about this case?
I did.
And he indicated,
That he did.
all right, so you had him acknowledge the waiver of rights form, and then he essentially wanted to tell you basically more about his side of the story, so to speak.
That's correct.
And again, were you threatening him in any way?
No,
Did he ever invoke any of these rights during this interview?
he did not.
So the interview just concluded naturally after he finished telling you what he wanted to tell you, and you asked any questions that you wanted to ask
Yes,
without him asking for an attorney?
that's correct.
All right, thank you. Those are all the questions that I have for this witness, Judge.
All right. Thank you, Judge. Mr. What is it, detective, is that what I call you?
Investigator is fine.
Investigator, sorry. Good morning, how you doing?
Morning.
First time you spoke to Mr. McNabb was October 7th, and that was, did you speak to him at the scene? Did you get any information from him at the scene?
Yeah, I spoke briefly to him at the scene.
Were you aware that there were body camera data available at that time?
Yes.
From other officers? Were you able to review the body camera footage at that time?
Not at that time, I have since though.
Right. And other officers had been speaking to him since earlier in the morning, and that's evident from the body cam. Is that fair to say?
That's correct.
So the child was first reported missing, 8 o'clock in the morning, something?
No, I think we got the initial call approximately 10:30 in the morning, something like that.
Mm-hmm. And how long did it take you to report to get to the scene?
I responded as a secondary assist. Corporal Freeman arrived on scene, and then he sent out a group text to all the investigators seeking assistance trying to find this child.
Okay.
So naturally, with the situation, almost everybody in CID responded.
Okay. Is Corporal Freeman, would he be considered the lead investigator in this case?
At that point, he was, yes.
But you are now, is that correct?
That's correct.
You took Chris McNabb and Courtney Bell, you took them to the Sheriff's Department,
I didn't take them personally. I had them.
and they were taken in a patrol car?
That's correct.
You said they were not handcuffed?
They were not.
Isn't there a policy regarding riding in the back of a patrol car where you're supposed to be handcuffed? Is that standard policy?
Somebody's under arrest, yes.
And in this case, they were in the back of the car or the front?
I believe they were both in the back seats.
And handcuffs were never put on?
Not to my knowledge, no.
And you say that Mr. McNabb was not in custody at the time that you interviewed him, is that
That's
correct?
correct.
But you read the Miranda warnings anyway,
I did.
and he agreed to speak with you,
You did?
and you let him go. Did you let him go at that time? You let him leave at that time?
After we were done, yes.
Did you give him a ride home? Did
He
somebody-
was given a ride home, yes.
So the next day, the child was actually found,
That's correct.
and you wanted to speak with Mr. McNabb regarding this case, but you also were aware of a probation warrant, is that correct?
Yes,
And you or someone in law enforcement had been in touch with his probation officer in order to kind of get that facilitated, is that correct?
yes,
The probation warrant wasn't actually pending it on October 7th. It was actually signed and initiated on October 8th, is that correct?
It's my understanding that it was pending prior to, by his probation officer in Barrow County. And it was actually signed and done on the 8th, yes.
Okay. And that's because you didn't have enough evidence to arrest him for the disappearance of the child, of his daughter at that time, but you still wanted to speak to him and get him into custody, is that correct?
That's correct.
And he spoke to you briefly on that day. I believe the full recording is about 50 minutes, but the actual conversation is less than that. Is that correct?
Yes,
All right. And at the end, he said he wanted an attorney,
you did.
and he didn't want to answer any more questions unless he had an attorney.
That's correct.
At that time, he had just been arrested, so he probably did not have an attorney at that point. Is that to represent him at that point? Is that fair? In other words, you didn't have anybody to call at that time? And
No.
Okay, so that's why you ended the interview.
That's correct.
And are you familiar with the process of obtaining an attorney if you can't afford an attorney?
Vaguely, yes.
And you are aware that my office was appointed within 24 to 48 hours after this interview where he asked for an attorney. Is that correct?
I don't know exactly the time frame of that, no.
You were aware that I was appointed.
Yes.
Is that fair? And we know each other, correct?
That's correct.
And you know how to get in touch with me if you need
I
to.
do.
Okay. So after Mr. McNabb said, I don't want to answer any more questions without an attorney, the next thing that you heard from him was a note that you received on December 13th.
That's correct.
And apparently the note was written on the 11th, or
Yes.
the information was received on the 11th.
That's correct.
And it took a couple of days to get to you. Is that fair? But as soon as you got it, you went to go speak with him.
I did.
Did you actually speak to Corporal Freeman about his conversation, or did you just go by the letter? In other words, did you ask any of the two people who said Mr. McNabb wanted to speak to you, did you talk to them directly, or did you just go by the little note that you received?
I was given the note by Corporal Wade,
Okay.
who is not Corporal Freeman.
Right.
Two separate people.
Okay.
And we briefly spoke about the note, and then I had him brought up.
Okay. And did you think to call my office to assist you and to be there with Mr. McNabb?
I did not.
And you, in fact, didn't attempt to contact me.
No.
You instead directly went down and spoke to Mr. McNabb.
Well, I had him brought up to the interview room, yes.
And that's where the conversation in the transcript from that day, December 13th, that's where the conversation began as far as you're concerned. Is that correct?
Yes.
The first interview on October 7th, again, you noted that he was in the interview room almost 6 hours. Is that correct?
Approximately, yes.
All right. He wasn't speaking with you directly that whole time, but he was there from 1:30 until, I assume, close to 7:30 in the evening. Is that fair?
Probably, yes.
Okay. And again, he had been, since 10:30 that day, he had been around law enforcement, had been talking to people. Is that correct?
Yes.
So overall, we're talking about close to 9 hours of constant exposure to law enforcement trying to help find his daughter or trying to speak with him. Is that correct?
Trying to find his daughter, yes.
Okay. And then October 8th, he was in the room for 50 minutes. The conversation was not necessarily 50 minutes, but as soon as he asked for an attorney, you concluded the interview.
That's correct.
And on December 13th, the conversation was approximately 2.5 hours, but he was in the room approximately 3 hours.
Give or take, yes.
And you never threatened him? Has the word death penalty ever come up and when you're speaking with Mr. McNabb?
I believe he brought it up in the conversation.
Okay. Did you ever tell him that if he didn't cooperate, that he might receive the death penalty?
I did not.
That's all I have, Your Honor.
Okay. Ross, do you have any questions?
No, sir, thank you.
Ms. Lyon?
Just briefly, Judge, Ms. Bell has not raised a similar motion, but I do want to tender for this witness her Miranda forms for the record, just so they're part of the record. So again, earlier I asked you, Investigator Alexander, if you had advised Ms. Bell of her Miranda rights on the same day of October the 7th of 2017 when you spoke with her, and you indicated that you had.
I did.
So I'm sure, and you stated, number 5. So with back to State's Exhibit number 5, do you recognize this form?
I do.
What is that?
It is Miranda rights waiver form that we went over with Ms. Bell.
All right, and did she, again, acknowledge the same rights that you had advised under Miranda to Mr. McNabb on a exactly identical form.
That's correct.
And did she sign that form and waive those rights and agree to speak with you on October the 7th of 2017?
She did.
Okay. Lieutenant of State's Exhibit number 5 into evidence.
No objection.
Mr. Carter, do you have any objection?
No, that's
No, without objection.
She was arrested in January of this year. Is that correct?
That's correct.
And once she was arrested in Conyers, she was brought back to our jail, and subsequent to that, you went and spoke with her in our Sheriff's Department on January the 7th of 2018.
That's correct.
Did you also advise her of the rights under Miranda versus U.S.?
I did.
I'm going to show you State's Exhibit number 6. Is this the form that you used to advise her of her rights during that time?
It is.
And did she agree to waive those rights and sign the form acknowledging that she has not been promised anything, has not been threatened in any way, coerced, or forced to make a statement, and was willing to speak to law enforcement?
She did.
I'd offer State's Exhibit number 6 into evidence.
No objection.
No, without objection.
Those are all the questions that I have, Judge, for this witness.
Mr. Frost, do you have any questions?
I do not. Thank you, sir.
Mr. Carter, do you have any?
I do not, Your Honor.
Okay. You may step down. Any other witnesses, Ms. Saunders?
No, Your Honor, not on this motion.
Mr. Carter, do you have any witnesses you wish to present?
I do not, Your Honor.
Mr. Frost, do you have any witnesses you wish to present?
I don't, sir.
What's the closing comments?
Judge, based upon the evidence, the state has met its burden of showing that the statements that were given by Mr. McNabb on October the 7th, 8th, and in December of last year were all given freely, voluntarily, and knowingly, that he had not been threatened or offered anything to speak with investigators. He had not been coerced in any way or deprived of food or drink for long periods of time. In fact, he was offered drinks even after he was in custody on the 8th. Was offered ice to go into his drinks. The defendant was not promised any sort of hope of benefit. There's been no evidence presented during this hearing through cross-examination of the investigator that he was threatened in any way with a particular penalty or outcome of his sentence if he agreed to speak with investigators. And the evidence actually shows that when he did invoke one of his rights, which is the right to have an attorney present, the interview immediately ceased. It ended at that point in time. That's uncontroverted evidence here. The defendant was sent back to the jail. It was only at the defendant's request in December, after apparently numerous occasions, according to Mr. McNabb, trying to reach out to our investigator, Jeff Alexander, was investigator Alexander then notified that Mr. McNabb wanted to speak with him, and subsequently followed up and spoke with Mr. McNabb at the request of Mr. McNabb, and that's been clearly established through the note that was presented at State's Exhibit number 4 and the transcript that Mr. Alexander shared with the court, which is an accurate reporting and transcript of the statement where Mr. Alexander took extra caution to make sure that it was in fact Mr. McNabb's wish to waive his right to an attorney, wish to waive his right to remain silent, and wish to re-engage or reinitiate conversation with the investigator. That was done so lawfully under the law. There's been no evidence presented by Mr. Carter or to controvert, I guess, the state's presentation of the evidence that this was done freely and voluntarily at the request of Mr. McNabb. So we've met our burden, and we ask that the court deny the defendant's motion.
Carter?
Judge, I don't have any specific argument regarding the first two statements. But at the end of the second statement, Mr. McNabb said, quote, I want a lawyer straight up. I don't want to answer no more questions. Now, I want a lawyer. I ain't got nothing else to say but that. That's it. And he was subsequently appointed an attorney. I currently represented him on December 13th. Mr. Alexander received a note from another party saying that Mr. McNabb wanted to speak to him. It was incumbent upon him at that point to contact my office and to make sure that I was there, because that's the last that he had heard.
That's the law?
That's the last that he did.
I thought the law was it's the defendant's rights to talk, not the attorney's rights. It's the defendant that has to invoke those rights, not the state. And if he volunteers or wants to volunteer to talk, that's perfectly within his rights.
I understand, but the message that Mr. Alexander received was not that I want to speak with you without an attorney. It was that I want to speak to you, and the last thing that he had heard from Mr. McNabb was, I don't want to speak to you without an attorney.
That's why he would have to start out the whole interview to ensure that he did want to speak to. without an attorney, which he gave the rights again, as I understand it, which contains all of that.
That's correct.
If you've got some case law that's contrary to what I understand the fundamental law is, I'll certainly look at that case law, but I think they're on real solid legal footing. They're under no requirement, if he wishes to speak, to notify you first before they engage in speaking, because quite candidly, no attorney would allow the defendant to speak in those circumstances.
That is correct.
So that would abridge the rights of the defendant to be able to speak if he wanted to.
Actually, that is the state of the law, and I agree that it would have been incumbent upon Mr. McNabb to again say, "I told you I didn't want to speak without a lawyer," and he didn't do that in this case. The only other argument I have is that this case had progressed 2 months. Ms. Zahn was certainly involved. The DA's office was certainly involved. Ms. Zahn herself could not have gone down to speak, being a party to the case, could not have gone down to speak to Mr. McNabb without first bringing me. And she was able to do so through Mr. Alexander, which again, I think it's just
Are you contending then that Mr. Alexander and Ms. Zahn on the telephone, and she was directing the questioning at all?
Yes, sir.
Well, the whole point was that she wasn't brought into the equation either.
Right.
And neither attorney was brought into the equation. This was typically just only between the defendant who requested to speak to the officer and the officer. And as I've already stated, I think that's permissible under the law.
Understand.
The court is going to find on each of the 3 statements that the defendant was apprised of his rights each time under the Constitution and under the Miranda decision, that in the first instance on October the 7th, he was not in custody, but however, on October the 8th and December the 13th, he was in custody on those 2 times. The court's also going to find that at no time was he threatened on either of the instances or offered anything to try to obtain any kind of interview or questioning of the defendant. That the December the 13th interview was only at the instigation of the defendant himself, not at the instigation of the law enforcement. And on the October the 8th one, once he did invoke his rights, that interview immediately ceased. The court finds that on each instance under Jackson-Denham, the state's carrying its burden on the first prong of the test, and the court will allow the interviews to be given to the jury, along with the other evidence, so that the jury themselves can be charged at the end of the trial to make their own determination about the voluntariness of the interviews. But this court finds that each interview was voluntary, given, as I've already indicated, and ceased when the defendant invoked his rights on October the 8th. Are there any further findings required by anybody on any of Jackson-Denham hearings?
Not from the defense, Your Honor.
Not for the sake.
What other motions are there, Ms. Lyon?
I know of no other motions that have been filed, and I confirmed that with both Mr. Carter and Mr. Frost prior to today's hearing. Also, Judge, I believe all discovery that the state has in its possession has been served, and it's my intention to go over with Mr. Alexander today his file to make sure. I know the Miranda forms were not included in what was served in the discovery. Those were in Mr. Alexander's file because they were originals. But I intend to make sure that every single thing in his file has been served today, and the state amounts that we're ready for trial.
For Mr. McNabb, Your Honor, we feel like we have received discovery. We've exchanged discovery with the state. There are no further motions at this time. I do know that I'll have a few motions and limiting trial motions, but I will certainly file those as quickly as the need arises or whatever. After speaking with Ms. Dawn about what she intends to exclude or whatever, I think we can work out a lot of the issues. Beyond that, we are ready for trial.
Mr. Frost?
Ms. Bell is ready for trial as well.
Now, there were comments made out here about body cams of officers and everything. Have y'all been given those?
I believe I have, Your Honor. I have several.
Let's make sure that the state gets with the sheriff's department, make sure that all videos, cam things anything been done by any of those officers out there or made available?
We have, Judge, and we've actually met with all of the law enforcement officers and almost every witness on the case, fact witness, to ensure that we knew everything and we had served that. And we made another video with the help of Sandy Springs Police Department. We've served that or made that available for them to be able to view as well and monitor the video. But we'll be glad, Judge, to again sit down and make sure they have everything for Investigator Alexander's file. I think we've gone through extra efforts in this case to make sure all discovery was served.
Anything else from the defense?
No, sir.
I'm tentatively going to say, that's very tentative, that we're going to try, see if we can't try this case sometime in August. That's going to depend on courtroom availability, and of course, we're going to go to construction at this courthouse. So we'll have to work around that, or try to work that in, but I want you all to look toward that, so that we can push for that. Anything else from anybody?
No, sir. No, sir.
No, Your Honor.
Then we're going to set it down for jury trial. Like that. We'll be in recess.